Welcome back, Bantwana Benkosi. This is Power Talk with me, Mbuyiseni Ndlozi, on Power 987. We're now going to turn into a very important matter of remuneration of the judges and the magistracy. There is a claim that they are basically not being properly paid or properly remunerated. Perhaps it explains some of the problems of that Mkwanazi was speaking to in a way. But we're joined by the member of the subcommittee on remuneration, Mr. Hennie Britz. Welcome to Power Talk, and thanks deeply for joining us.
Good morning, and good morning to your listeners as well.
Thank you indeed. I'm also joined by Neelan Karikan from the president of the Judicial Officers Association of South Africa. Welcome to Power Talk.
Thank you so much, Dr. Ndlozi.
And as well as Mbekezeli Benjamin, Research and Advocacy Officer at Judges Matter. Welcome, Mbekezeli.
Good morning, Dr. Ndlozi, and good morning to my fellow panelists and the listeners. Thank you.
Thank you. Let me start with you, Mr. Hennie. What are the bases, if you were to patiently take us through this remuneration gap, and on what data is it based on? Is it much more recent data, or are we looking at a matter that has been longue durée, meaning it has been going on for 10, 15 years? I don't know if you are able to paint it patiently for us.
Yes, thank you, Dr. Ndlozi. Just a bit of background. I myself used to be a magistrate. That was around about 35 years ago. And after that, I've practiced as an attorney, and presently I'm a member of Parliament, and I represent Parliament on the Magistrates Commission, and where I sit on the subcommittee for remuneration of magistrates. So I have quite a lot of institutional knowledge myself on the subject. So let's go back before 1994 and the democratic dispensation, where magistrates were treated as public servants, and they received remuneration as public servants. In 1994, with the interim constitution, things changed a bit, and the magistrates were lifted out, and they became so-called independent. That also had a huge impact on the salaries back in the 90s of the previous century. But what we've seen over the past 30 years is that the magistrates' remuneration stayed behind in terms of the remuneration of judges. Now we do have to bear in mind that judges comes from the advocacy, and which is not necessarily the case with magistrates. We do see more and more advocates and attorneys being appointed on the bench as magistrates, but fact remains that if we compare the salary scales of judges with those of magistrates, there's a huge discrepancy. What also happened over the past 3 years is that the jurisdiction of the regional courts as well as the district courts increased tremendously. For example, a few decades ago, as a regional court only had jurisdiction on, for example, culpable homicide, and the maximum sentence that they could impose at that stage was 10 years imprisonment. At this very moment, what we do see is that regional courts do a lot of work that the High Court used to do, such as murder cases, rape cases, and remember, magistrates courts, especially regional courts, can impose life imprisonment. So they gained a lot of more responsibility over the years, but still their remuneration does not equate and does not take into account the responsibility that they carry currently.
Can you put that in numbers for us?
Yes. a regional court magistrate, roundabout gets 1.2 million rands per annum, if I'm not mistaken, while a High Court judge will get over 2 million rands. And the huge difference is when a judge retires, he will get a pension for the rest of his life, okay? Which is not necessarily the situation with magistrates. They are not going to receive a pension on the same scale. They are treated like public servants, pension-wise. So the Magistrates Commission has embarked on a road to look into and investigate the discrepancies between the magistracy and the judiciary, while both are doing actually the same work.
So what recommendation did you give to the President regarding the remuneration review?
Okay. Personally, I can't give recommendations, but my committee made some recommendations to the Magistrates Commission. The Magistrates Commission did have their last sitting last month, and there is a committee meeting coming up, or commission meeting coming up shortly, where this matter will be raised again.
Okay, Mr. Karikan, let me bring you in now. Firstly, just to explain to our listeners the organization and your reaction to the opening statement by Mr. Britz.
Thank you so much. As the president of JOASA, JOASA is the Judicial Officers Association of South Africa. We are the largest association in the country of judicial officers. We are close on 800. We have members that include High Court judges, regional court magistrates, but the majority come from the district court. The district magistrates court.
It's like some form of a union.
It's not a union, it's an association. I don't think we are allowed to be unionized.
I see. What is its purpose?
The purpose is to promote the interests of judges generally, particularly the lower courts, which we refer to as the lower court judges, when it comes to security, remuneration, protection, housing, and the benefits that they ought to get in order to be able to operate freely, fairly, independently, impartially. So those are the issues that we try to promote. And part of that promotion, you will see, and when we continue the discussion, you will see to what extent there has been systematic economic discrimination against this class of individuals in the form of the lower court judges and the magistrates in particular. So that's where we are at right now. Okay,
yeah, but address us then on this remuneration question. The as I understand, about 90%, 95% or so of South Africa's judicial workload lies at the lower courts. That's the first claim. And are these the numbers? They don't get permanent when they a permanent pension on the one hand. On the other, they are earning in the rank of about R1 million annually.
Yes, it's very important for us to understand, and the colleague has, to an extent, but very limited extent, explained the difference. In as much as the colleague might have been a magistrate many decades ago, things have changed, and he is correct. When it comes to judicial officers, when it comes to judges, whether you're in the High Court or you're in the lower court, we are doing the same work. We are applying the same law. We're using the same Criminal Procedure Act. The Civil Procedure Act is the same. The maximum penal jurisdiction in this country, as correctly pointed out by the colleague, is life imprisonment. Judges give that. They can't give anything higher. There's no death penalty. Magistrates, lower court judges can give life imprisonment. And we do. For premeditated murder, rape, armed robbery, we do that. And remember, in the district court, we are the court with the largest jurisdiction as the court of first instant. When it comes to family court matters, domestic violence, harassment, children's court, we do civil trials, motion court, every aspect that you can imagine that ordinarily would operate in the High Court, we do it in the lower courts.
So essentially, there is no substantial difference between a high court and a magistrate's court.
To my mind, there is actually nothing, except for the fact that we use this term inherent jurisdiction and regulate your own proceedings. But that's where it ends.
What does it mean?
Regulating your own proceedings and having inherent jurisdiction allows you a lot of latitude to deal with any aspect of work that might come to you. And in terms of procedure, you're not regulated or stifled like magistrates, because a magistrate has to work twice as hard, to my mind, because the magistrate is regarded as a creature of statute. You are regulated by whichever legislation comes before you. So you got to act within the ambit and procedure of whatever legislation comes before us. So we don't have the latitude of saying, okay, we'll overlook this procedure. So to my mind, it's more difficult to be a lower court judge or magistrate, because you got to make sure that you are confined to the four corners of whatever authority you have.
Isn't one of the differences, and perhaps precisely to this question of remuneration, training?
Training is very important.
And high court judges, like relatively more educated, more trained, better skilled than magistrates.
I disagree with you. The qualification of our magistrates, quite a few of them are already more qualified than high court judges. The qualification is the same, whether you have a BA law degree, LLB, whether you come from the attorney's profession or you're an advocate. We have all of those individuals within the magistracy.
But are they a requirement in the same way they are for the judges in the high courts?
A judge just needs to be fit and proper. A magistrate needs a certain number of years of postgraduate experience in order to qualify to even to be appointed. But the qualification aspects are the same. You must understand, as it stands, many magistrates are being appointed to the high court, whether they come from the district court, the regional court, but they meet the grade, and they are acting in the high court. So when we talk about acting high court judges, acting magistrates, the individuals are coming from advocates' professions. You know, the majority ordinarily used to come from prosecution before when it came to magistrates. But that's not the case now. Right now, the case is that we are receiving people from the private practice with lots of experience. They have 20, 30 years experience. And our magistrates, a lot of them have 30 to 40 years of experience on the bench. So we cannot call them junior. And we need to also be very careful when we talk about how the judges operate. Remember, the judges have judges' clerks, they have researchers. You don't see that with a magistrate. A magistrate must listen to the case.
Magistrates don't have clerks?
We don't have clerks. We don't have researchers. When we talk about clerks, we have the clerk of the court. The clerk of the court is the person that issues documents. There is no clerk allocated to an individual magistrate, as would happen with a high court judge, where you get this individualized treatment, access to information, internet, research tools. Magistrates don't do that. They have to do everything that they do on their own and still have to be taken on appeal and review. Under those circumstances, Dr. Ndlozi.
Yeah, Mbekezeli, I don't know this question of the differences in training and judges specifically of a much more rigorous process than magistrates, and maybe that justifies the differences in remuneration.
Look, I agree with Mr. Karikan to say the quality of the magistrates and the pools from which we draw them in 2025 is very, very different from if you look back 30 years ago. The kind of requirements and the kind of rigor that is today required of a magistrate is almost that of a judge, right? They're scrutinized in the same way. They have to be experienced. You have to have a qualification. Before, in the past, you didn't even need an LLB degree to be a magistrate. But today, you can't be a magistrate without an LLB, and you can't be a magistrate without significant years of experience. Similarly with judges, in as much as it's not specifically written in the law, there is no way that you can be a judge without a significant amount of years in legal practice.
But what is the difference? What is the difference these days between these courts? Why are you Why would the country still insist on an ocean between magistrates and judges?
Look, there is a difference.
What is the difference?
The difference is the scope of work. Mr. Karikan was quite right to say that magistrate courts today deal with a lot more work than in the past, and that's because that's a scope that has been increased by Parliament. And so the primary difference is the scope of powers and the scope of practice of a magistrate and a judge. The fact that the judge, the High Court, for example, has inherent jurisdiction and has constitutional jurisdiction means that, for example, a High Court can set aside the decision of the President. They can set aside a decision of Parliament. They can reverse decisions of government departments. So the scope of work that the judge does.
Magistrates can't do that. What about the decision of a mayor?
The decision of a mayor similarly will have to be decided by a High Court judge. You can't take it to the Magistrate Court. And the reason is because the Magistrate Court primarily rely on Parliament expanding or determining the scope of their work, which is not to say that they are not doing significant legal work. As you quite rightly point out, 95% of cases that we have in the country go to the Magistrates Court, and as Mr. Britz and Mr. Karikan explained, today magistrates deal with a lot more complex issue. But the primary basis of magistrate scope of work is a decision by Parliament, which is quite different from judges. They primarily determine their scope based on what the Constitution decides, and their scope is quite wide. They can have quite a wide scope of work, so inherently control their own processes. So, like Mr. Karikan said, a judge may decide that in this specific case, for the interest of justice, we can disregard certain procedures. Magistrates cannot do that.
Let me bring Mr. Britz, and I don't know what is the Commission's understanding. I must confess, I used to serve on the Magistrates Commission, but today, what would you point as the difference between the high courts and the low courts?
Okay. First of all, let me just say that Jawasa and I are on precisely the same page regarding the differences between the High Court and Magistrates Court. I think we echo one another's sentiment. Secondly, it is very clear that there is a discrepancy that is not based on fact in the remuneration of magistrates versus remuneration of judges. I totally agree with Jawasa, where they say that magistrates and judges comes from the same pool of lawyers. And according to me, and I've been practicing for the past 3 decades in high courts as well as magistrates courts, we cannot say that there's a difference in training or difference in intelligence or difference in competence or difference in qualification. Magistrates and judges are drawn from the same pool of lawyers, and all of them are equally qualified and equally competent.
What justifies then the sort of difference in remuneration if these people are doing the same job?
That is precisely where I think Jawasa and myself agree. There is no justification. There has not been a justification, and especially now when we look at the workload and the cases that comes before magistrates, there is no justification for this discrepancy.
Yes, I see Mr. Karikan wants to jump in. Yes.
Thank you so much. When we talk of jurisdiction, Dr. Ndlozi, remember...
Mbekezeli says there are certain decisions that the lower courts are not competent to take. It will take some parliamentary resolution, it seems like, setting aside, maybe those matters that have to do with the separation of powers.
Mr. Benjamin is 100% correct. There are certain but very limited aspects that we don't deal with. We need to be very mindful. When we talk of constitutional issues, we are dealing with constitutional issues. Remember, in the Magistrates Court, we are sitting as equality courts. What do you think we are dealing with? Equality Court, it directly comes from the Constitution, the Equality Act.
So
and we
equality
preside.
courts are part of the lower courts.
The lower courts and the regional court and the high court. So we are doing the same types of work, same principles are being applied. We apply PAJA, PAYA, POPIA, all those acts we are dealing with when it comes to PI constitutional issues.
Are you able to set aside a decision of the head of state? On, for instance, on any matter that might come in front of you? Because this is Mbekezeli's point.
On a soft note, not yet.
Not yet. And
really
isn't that a big difference?
But we are dealing with reviewing, for example, we are dealing with the traditional courts that have come into operation, the Act. So there are issues that come before us when it comes to those types of review. And we spoke of PAJA, PAYA. We can accept. There's a hierarchy of a system. We all must accept it. Not every judicial officer can have the duties or the functions or the authority of the constitutional court judge. But we are judicial officers nonetheless on a proportionally different scale. But our issue is why treat us different, like a stepchild within the judiciary? Because we say we have a single judiciary, but do we really? Why are we falling under the executive and the commission? When we talk about the commission, you will notice that the commission largely deals with misconduct.
Yes,
not about
the
the
Magistrates Commission. Yes.
Not about the well-being
They
of a
appoint
magistrate.
as well.
Appointing of acting magistrates, and you will notice that we got close around 2,000 magistrates. Why do we have 30 to 40%, to my mind, that are acting in perpetuity? You take them from the attorney's profession, from the advocate's profession, you give them some type of employment for a short period, and then you reject them after like 2 years. So they must go back and build up their practice. And in the meantime, we are not filling in those posts. Why is that?
It's 11:30, Bantwana Benkosi. We're going to continue with this conversation after the headlines. The true implications in relation to ethics, in relation to the quality of judgments that the remuneration has. Let's take the headlines with Nyakalo Tefu.
Stay informed. Power Talk with Mbuyiseni Ndlozi, 9 a.m. to midday on Power 98.7.
Indeed, we are still teasing out this matter of inequalities in remuneration between the judges and magistrates in the country, and the claim that actually magistrates deal with 95% of the load on the courts. Mr. Britz, what do you think then are the implications of this low remuneration? Does it render the magistracy as an unattractive sort of career for most lawyers, and therefore maybe we get to end up with the least skills in the profession?
Yes, I hear what you say, but I don't agree totally. To serve justice on the bench is a very high honor, and remuneration should equal that honor and the responsibility that comes with it. You know, as you've mentioned, 95% of court cases are dealt with by the magistracy. And therefore it is very important that we look after our magistrates, especially when it comes to morale. As you also pointed out, magistrates don't have the privilege of their own personnel. They don't have the privilege of their own clerks. They don't have the privilege of their own secretary. And we have to look after the morale of our magistracy.
We read, the UCT, for instance, published a study where they argue, it's titled Under Pressure, 10% of magistrates had been offered bribes, while nearly 50% had witnessed an unethical behavior amongst their peers in 2022. Magistrates lack, and they put this to, certain benefits such as 2-year tax-free salary upon retirement, and so on and so forth. In a way, the study attributes this vulnerability to the remuneration condition. Do you agree with that, Mr. Britz?
Okay.
You are seized with the majority of these cases at the commission. What is the status? I mean, are you dealing with a lot of misconduct?
There is a subcommittee on this disciplinary matters, and I'm not sitting on that subcommittee for disciplinary matters.
But it serves, the reports ultimately come to yourselves there.
Yes. So at this very moment, I'm going to refrain to make a very strong statement regarding disciplinary matters. But what I do want to say, yes, like in any other profession, you get your rotten individuals, but that does not make the whole bag rotten. That only means.
But how much of these rotten potatoes? Where would you put it? This study puts it at nearly 50% of unethical behavior in the magistracy.
I will very much like to differ with that figure of nearly 50%. What I can say, out of my own personal professional experience in our courts, I've only received very professional conduct, and I've seen professional conduct from magistrates. So whether it's widespread, I really doubt whether it's widespread.
Mr. Karikan, I don't know. Of course, you are an association that speaks on behalf of your colleagues. The study puts unethical behavior in the magistracy to nearly 50% on the one hand. But on the other, you might have heard the general yesterday as well, decrying corruption at the level at which cases are brought. Where would you put it, the unethical conduct? And do you agree with the study that there's a correlation between that and being underpaid?
I don't necessarily agree with that study, because you've heard Mr. Britz, and Mr. Britz is speaking from the perspective of the commission.
I do too. I used to see it there.
Exactly. So you understand.
I used to see it in the disciplinary committee.
Correct. So
huge numbers,
but not 50%.
Okay.
Let's.
What
let's
would be
clear.
50%? You represent 800 judicial officers.
Correct.
What is the percentage of your? What percentage of the judiciary, if you are representing 800, what is that percentage?
I haven't done the calculation, but I would peg it at least 45%.
Okay.
At least 45%. But be that as it may, Mr. Britz has highlighted, he's in the commission currently, and he's pointed out that the number is not to that extent, firstly. But let's not detract. Our issue relates to remuneration, and I always tell my magistrates and my lower court judges, when you join this profession, you are not going to get rich, but you can live contently. But right now, as it stands, we cannot even live contently. When you look at what our package is, we can talk about R1 million. Looks like a lot of money. When you break that down into rands and cents, you'll be lucky to see 50,000 to 55,000 net. Now, as a magistrate, you must pay your bond. You must send your children to university. You need to pay for the car, mate. The
expectation, obviously, is that you are part of a class of people that went to school, who've got degrees.
Correct.
And your colleagues in accounting, your colleagues in engineering are doing more.
But it's not about the money.
Yeah.
As Mr. Britz has pointed out, it's a calling. We like what we do. But
don't
starving.
You agree that these struggles may avail majority, or at least a significant part of the magistracy, to be vulnerable to bribes?
I've conceded that point previously in another interview, and that's common sense. But not everyone will succumb, and I've pointed out that the majority of our judicial officers are up to scratch. And I use the word funny things. They don't do funny things. But you will get those people who might be misled and end up doing unethical issues or conduct.
Behavior,
But then the commission, we speak about the commission. Why did they take 5 to 6 years to deal with these individuals? Only recently they've been fast-tracking it. And now that they are fast-tracking it, it seems that their only focus is on misconduct. They can deal with that. It's a one branch. But remember, The Commission is responsible to make recommendations and regulations to the Minister when it comes to leave, when it comes to acting appointments. Why do we have so many? When it comes to transfer, do you know, as a magistrate in Randburg, I've got to apply for a similar position and compete with other individuals for a position, for example, in the Western Cape or KZN. Why should that be? I'm already a magistrate, I'm fit and proper. Why has the Commission not taken it upon themselves to administratively attend to where transfers are feasible, get it done? Because our people on the ground, they are crying. Their parents are in different provinces and they cannot even get to them or look after them. They are aged and they are sick. So
Mbekezeli?
basic stuff, basic stuff.
Yes. So I was actually going to jump in there about the study because it was actually conducted by my team and I at the University of Cape Town.
Yeah, the two magistrates here, they're dismissing it as a false study.
But that's because
the judgment on this matter is that it is false and it is dismissed.
Well, I think let's go to the facts. What we did actually, we looked at, we did a survey of magistrates, and we did it both before COVID and after COVID. And we surveyed about 230 magistrates across different ranks, across different provinces, to try and get a sense of what is happening with magistrates. And what we found there, actually, the title of the report is called Under Pressure. And that's because we found that magistrates are under pressure, both in terms of workload, but in terms of remuneration. And the concern was that for well over a decade, the remuneration for both magistrates and judges have not kept pace with inflation, for example. It is gradually being eroded. In fact, what the other studies found is that a judge, for example, in 2009 was earning more in real terms than a judge in 2021. And so what the study found is that because of the pressures of remuneration, there was a concern amongst magistrates, and that's what they told us, that's where the 60% comes from. There was a concern that because of the pressures of remuneration, they are vulnerable to bribery and corruption. This is not to say 60% of magistrates are taking bribes or are corrupt, but they all reflected, to say not 60% of the 230, they all reflected that they feel under pressure. And we tried to trace this also at the Magistrates Commission level. So we looked at the records of the Magistrates Commission for about 15 years and looked at the number of cases that have come in, the nature of the cases. And what we found, which was not surprising to us, but when we put it against this pressure of remuneration, what we found was that there was actually a very small number of cases involving bribery or corruption. And that is compared against all other cases of misconduct that the Magistrates Commission deals with. And in fact, there were, I think, only about 3 cases that have gone to the level of the impeachment of a magistrate based on allegations of bribery. So even there, the number is small. So the point is that there are very few cases where magistrates have either been alleged to have accepted bribes, or there are even fewer cases of a magistrate being prosecuted for corruption. But because of the pressure of remuneration, that they are not getting the salaries that they should be getting for people in their positions, they feel under pressure and they are vulnerable to this bribery. And that, again, links to what the General mentioned yesterday, that he alleges, there are allegations that there are some magistrates on the tape. We don't actually have physical evidence of that, but what our study confirms is that the question of remuneration actually does have an impact. And that's where I think the focus should be. You asked earlier about why is it that there's such a discrepancy between judges and magistrates. And that's because of a failed reform process that has undertaken in the last 30 years. Mr. Britz spoke earlier about how magistrates initially were seen as civil servants, and they were supposed to be gradually migrated into the judiciary. But that has not really happened. And that's where you see that discrepancy in the pay and the salaries. But overall, if you look at judicial salaries across the board, from at the highest level, which is the Chief Justice, to the lowest district magistrate, they have not kept up with inflation, and that actually is a risk to being unconstitutional, because Section 176 of the Constitution is very clear that a judicial officer's remuneration and allowances and other benefits may not be decreased. And what we see is the effects of inflation is actually, in real terms, reducing the remuneration of judicial officers.
Mr. Britz, why are we not filling the posts? There's a claim here that there's about 30% acting positions, acting magistrates within the system. What is the problem of filling up those posts?
Okay, my personal opinion, what I've observed on the commission is that it is an administrative task, and the administration of filling of posts is most probably too slow. I know that, for example, the commission or the subcommittee that deals with the appointments or the interviews with potential candidates is held once per annum, and that takes a very long time. And I think the Commission should look into speeding up the administrative process of filling positions much faster.
But isn't it the job of the Commission to make this happen? What would be the administrative nightmare? Are you saying that the committee is overwhelmed administratively, or it has no administrators, or what is the precise administrative problem?
My personal opinion, the whole process from advertising or from declaring, advertising, up to the interviews, up to the appointment, that whole process takes too long. And I think it's high time for the Commission to clean up the act and to look into expediting the whole process from the point where a position becomes vacant until the position is filled.
Okay, I would then I will start. Let me start with Mbekezeli. What would be the correct remuneration that is adequate for the judiciary? I know you've already alluded to the fact that they must be treated equally since they do the same job. But today, if the president were to concede to this demand, how much must they be paid?
Well, before we even get to the numbers, Dr. Ndlozi, because I think we need to all understand why and what is the risk of not paying judicial officers properly.
Is that they'll be bribed?
Yes, that will be bribed.
Okay, how much do we pay them so that they are not bribed?
So the question is, how do we make sure that, first of all, we protect them from bribery, but secondly, we attract the very best lawyers. So a lawyer should be able to give up a practice incentive and be able to be a magistrate tomorrow if it was attractive enough. Of course, like Mr. Karikan says, no one goes to be a judge or magistrate to be rich. You understand that it's a sacrifice and you're doing it for public service. But the question really should be, if you look at the legal industry, legal profession generally, what are the competitive prices? How do we ensure that we attract the best talent? Because I can tell you now, there's no question if there's a CEO of ESCOM or the CEO of a large government entity, they don't even talk about the salary because they know that they have to pay competitive market-related salaries. So the same should happen for judicial officers.
But what would that number be? What would be a market competitive salary for judicial officer?
So, for example, right now, the lowest paid magistrate earns 1.2 million rand. That is the salary of a junior associate at a law firm. And so how do we make sure that we actually bring them up to the level of maybe a director or a partner at a law firm?
Which is how much? You gotta learn to get to the point, Chief. Give a number.
It depends on the context and
he doesn't know. Let's go to the president here. Maybe firstly tell us about the court case that you're threatening, and but what is the actual demand beyond equalizing the salaries?
Yes, insofar as this potential litigation against our president of the country, I did point out that we are having a special general meeting at 1:00 today, and we already got unanimous support to actually engage in litigation against our president. Right now, as it stands...
How would it go? The judge is litigating. Which court is going to hear that?
We'll get to that, Dr. Ndlozi. What's important to understand is the president is sitting with a document called the Major Review. He's been sitting with it for the last 9 months.
Yes.
And this document was in process for the last 17 years by the Independent Remuneration Committee. It's sitting there. We're losing money. It's not being signed. It's not being sent to Parliament.
What does the document say?
The document speaks to more or less the figures. In fact, the figures as it stands, to my mind, is stale. And when you talk about what a magistrate or a lower court judge should earn, they shouldn't be earning too far below what a judge is earning. But we don't expect to earn what a judge is earning.
Why?
Because of the nature of the work, the seniority, it is a structure, there's a hierarchy within our court system.
But what would that number be? 10 ngakwazi uthetha ngale number.
I want to add that a judge of the High Court after 15 years of service gets 2 years of remuneration tax-free. Did you know that?
How much do you want?
But did you know that?
Yes, I do. But how much do you want?
We get nothing.
How much if the president concedes today, how much would that be?
We want a fair and livable wage.
Yeah, how much?
You can do the calculation.
I don't
want
want
does
to.
It cost?
For the benefit of the listeners, what would that be? 2 million? 3 million?
I will leave that to the president and the necessary
So
committees.
if the president comes back and increases it by 100,000, what are you going to do? You'll still go to litigation.
It doesn't seem fair and reasonable cost.
What would be a fair, reasonable cost?
Well, there's tax implications. They're experts for these things. I cannot
You
say.
are threatening litigation and you haven't worked out the number. I don't think the threat is valid. Eh?
No, it's a valid threat.
But
It's a
what
valid
would that
threat.
number be? What would be a good remuneration of
I would say a
magistrates?
lower court judge should earn at least 65% of whatever our Chief Justice is pegged at, because that is how we work.
What is our Chief Justice earning now?
I'm not sure.
Okay. You were speaking to the other benefits. What are they?
Other benefits, as I mentioned, long service remuneration or awards. Judges of the High Court get a 2-year tax-free ex gratia payment after 15 years of service. A magistrate gets nothing. After 20 years, and I'm repeating myself with other times I've engaged. After 20 years of service, a magistrate can sell 10 days of his own leave, which he's entitled to use, in order to get some money in the pocket to pay debt. After 30 years of service, a magistrate, a lower court judge, can sell 20 days of his own leave. And that's, so to speak, being purported to be a benefit. So I cannot go on leave. I must sell my leave to survive. That is the system we are currently working with, beyond other benefits that we don't speak of. It's easy to speak about a judge earns certain amount, a magistrate, but you need to look at the other benefits that surround that entity and ourselves as an entity. And you'll see that the discrimination has been systemic. It's been perpetuated for the last 30 years. And if you even look at our constitution, our magistracy is not even reflected in our constitution. You reflect every angle of judicial officer, from the Chief Justice, Constitutional Court Judge, High Court. But when you come to the magistracy, from our chief magistrates, regional court presidents, regional court magistrates, seniors, you don't even reflect them there. We don't belong in the constitution. We belong to an act. So we are relegated to an act.
That's why you are underpaid.
That is why we are treated the way we are. We should be reflected as lower court judges.
Mr. Britz, what would be a reasonable compensation for our judicial officers at magistracy level?
Dr. Ndlozi, let me put it this way. You're not going to get anybody to commit to figures, but what I think is fair, and this is what we as a subcommittee is also pushing for. On a sliding scale, on the same level and same grades as judges, the judiciary in South Africa, whether it's in the High Court or whether it's in the lower courts, should be on the same sliding scale. So starting with your Chief Justice being paid the most, and from there, pro rata payment to magistrates or the judges in the lowest courts. So I think that will be a fair dispensation.
And what does the Commission need to respond to vacancies with speed?
the subcommittee that does the interviews should sit more regularly. And not
Why
only
doesn't it sit more regularly?
Well,
As
there are-
urgently as the vacancies are needed.
Okay. One of the problems is a practical problem. Remember, all of the members of the commission are not full-time commissioners of the commission. It is all individuals with other work as well. So it is a practical problem to get everybody together to have the interviews, wherever the interviews might be. So it's a practical problem. And I think that should be addressed.
Okay. And then, Mbekezeli, I don't know if you want to, as Judges Matter, say something related to these question of vacancies. I know I didn't give you a fair chance to respond to that.
Yes, so actually, Mr. Prince spoke about it. It's just practically not possible. There are over 2,000 magistrates in the system. At any one point, when the Magistrates Commission does interviews and recruitment, they are recruiting for 200 positions. And that process alone takes well over 6 months. The interview sits from Monday to Saturday for about 3 months. And if you think about it, I know Ms. Umpile Mauto is a member of the Appointments Committee. I don't think she can sacrifice sitting out of Parliament for 3 months to attend to interviews. So practically, it's very difficult to do because of the volumes of the magistrates that need to be appointed. But it is not acceptable, actually. What I think should be a practical way to solve it is to increase the capacity of the administrative staff, is to double the number of commissioners that are on the Appointments Committee, because right now there are only 9 people. So if you had 18 people, you can have 2 processes running at the same time, and if you use the same standard, they should achieve the same outcome. But the other problem, like I said, it does go back to remuneration, both at the High Court level and even in the magistracy, that currently, unfortunately, is not longer attractive to be a judge, just because you sacrifice so much. You struggle to even get your children into school. And so we should fix that discrepancy first and foremost.
Okay. I'm sure you want to have a bite on how the Commission could improve filling vacancies.
Absolutely. We speak of capacity. And when judges get shortlisted, when they go for interviews, within a week, almost the next day, you know what's happening. Why are magistrates treated differently? And we need to look at how acting magistrates are appointed, and what someone is benefiting from this broken system. Because for us to have 300 or so acting magistrates in the country that you just chop and change, you come in and you come out, and you expect to get quality justice, because people are just, their heart is not with us. They've got their practices that they have to go to. So we need to fill in those posts ASAP, because they are funded posts. There is money for it. There is no excuse that we don't have the time.
Mr. Neelan Karikan, President of Judicial Officers Association of South Africa, thanks deeply for creating time to come speak to us today.
Thank you so much.
And Mr. Hennie, Britz, member of the Subcommittee on Remuneration, thanks very much for coming to speak to us this morning.
Thank you very, very much for the invitation.
Thank you. And Research and Advocacy Officer at Judges Matter, Mbekezeli Benjamin, always a pleasure. Thanks for coming to speak to us. Mbekezeli? Mkile.
Oh, thank you very much. Thank you very much.
Thank you. That's it from us here, Bantwana Benkosi. We are now going to move straight to Power Lunch. Please stay tuned for Power Lunch. But from us here at Power Talk, ndiyabulela until tomorrow. Ndinthanda nonke emakhaya.